Good morning, everyone. This is your first appearance hearing for the Magistrate Court of Clayton County. My name is Brad Gardner. I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You'll receive notice at the address you give of your next court date. Finally, would everyone please raise your right hand? Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God?
Yes.
Okay, thank you. Let's begin on the side.
Brett.
I did not receive the completed CAA forms, but I'll just ask the questions, qualifying questions, as we move along.
State your name.
Shakri Bradford.
Okay, Miss Bradley, we're gonna have to bring you back. Well, I'm gonna place you back at the end. There was a notation that they were unable to locate your file when I received the paperwork this morning, and I still don't have the warrants for you, or warrant. This is a misdemeanor criminal trespass, and you're entitled to bond on this. But I still need to be able to look at the warrant. So I'm going to ask the deputies to just place you back, and I'll bring you back at the end of the ladies. Miss Davis, or Davis Francis.
Oh, dude, I meant to send you an email and register her, but she COVID.
Okay. Well, I think you may have. That sounds familiar to me.
If I did, I'm pretty sure Deputy McKenna did.
Okay. So what I'm gonna do with her is I set, wow. Okay, so she has a bond set, but there's also a stay away provision on the bond. And I think, well, I not think I know, in order for the stay away provision to be valid, I have to address her directly. So I'm just gonna do a continuance order for her to bring her back before me tomorrow.
Yes, sir.
Okay, thank you.
State your name.
Ms. Freeman?
Jennifer Freeman, yes.
Ma'am, you're charged with one count of driving a vehicle with no insurance. The bond is going to be set at $1,000, and one count of, it says knowingly driving a vehicle with a suspended or canceled registration. Bond is going to be set at $500. So that's a total bond of $1,500. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No,
Okay. Do you have any questions of me?
no. Thank
Okay,
you.
man. You're welcome. You're free to go back.
State your name.
Bye, King.
Okay, Ms. King, ma'am, you're charged with one count of violation of Georgia Controlled Substance Act. Bond's going to be set at $3,000. Do you believe you can post that bond?
Maybe.
Okay, your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201, because this is a felony offense. If you're able to bond out, that court date will get waived, then you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Are you currently working, ma'am?
No,
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
no, sir.
Okay,
You said
ma'am.
it was- you said the court date was February 7th.
Yes, 7th. But upon bonding out, that date, as they say, by operation of law, that date gets changed and you will get a new court date in the mail.
All right, thank you.
Okay,
You can step back. Step up.
Ms. Parker?
Yeah.
Ma'am, you're charged with one count of criminal trespass. Bond is going to be set at $1,500. And one count of obstructing an officer. Bond's going to be set at $2,000. These are both misdemeanor offenses. There's a total bond of $3,500. Do you believe you can post that bond?
No, sir.
Did you say no?
No, that's a lot.
Okay.
How
There's
much
going to
would
be,
that actually
hold,
be?
hold.
Talk first, answer question at the end.
Yes, ma'am. At the end, you can ask me whatever question you want to ask me. There's going to be a stay away provision on this bond, stay away from an Alex Brown. Do you understand that?
Yeah,
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Now, would you like for me to see if you qualify for the appointment of a lawyer?
yes, sir.
Are you currently working?
No, but I received a monthly check.
Okay, so yes or no?
No, I'm not working.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, I cut you off. What was it that you wanted to tell me?
The bonds being set that high, how much does that really, do I really have to pay?
Approximately $300.
Okay, I can do that.
Okay. Is there anything else, ma'am?
At the preliminary hearing, is that where I go to plead guilty or not guilty?
No. If you bond out, that preliminary hearing date is waived by operation of law, and you'll get a new court date in the mail. So what happens is that once you bond out, your case goes out of magistrate court and it goes to state court. because I don't know what judge will get your case and what calendar that judge has, I can't tell you about court dates for that judge's calendar. And because that judge is an unknown right now, we can't tell you what date will be your true next court date.
All right.
Okay. Anything else, ma'am?
No, thank you.
Okay, ma'am, you're free to go back.
Thank you, ma'am.
Miss Williams, ma'am, you've been charged with 1 count of affray and 1 count of criminal trespass. There's going to be a $1,000 bond set on the affray charge, and I have dismissed the criminal trespass charge. So you're going to have a total bond set at $1,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No,
Okay, do you have any questions of me, ma'am?
no,
Okay, you're free to go back.
thank you.
Your Honor, we're bringing Brad back up now. We're gonna wait.
Um, let's bring Miss Bradford back up. Okay, ma'am. You are charged with 1 count of criminal trespass. This is a misdemeanor charge, which means that you are entitled to a bond by law. I don't have the warrant before me, so I cannot make a pinpoint determination as to what I believe is the reasonable bond. Generally, on criminal trespass, where you're at a place where you've been told not to come back to, I generally set a bond of $1,500. If you destroy another person's property, break their cell phone, punch a hole in the wall, destroy the door, I generally set a bond of $3,000. And I would most likely put a stay away provision on the bond. Because your paperwork is somewhere floating out by no fault of yourself, I am going to, unless you have an objection, I'm going to sort of split the baby, and I'm going to set a bond of $2,000. And I'm setting that bond so that you will be able to bond out. Without having the warrant, I may be placed in a situation of having you in jail another night while we try to locate the warrant. I have no doubt that this warrant will get found and located, but I'm not going to have you sit in jail because of that. So I'm going to set a $2,000 bond. So you now know that you can contact bonding companies or whomever to help make the arrangements for you to get out of jail. Do you have any objection to my doing that?
No, sir.
Okay. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, but that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, ma'am?
Yes, sir.
About how much do you make per hour?
1350.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
That's it. Email, John.
Okay, thank you for your assistance. Have a good day.
Yes, sir. Thank you.
All right, let's switch over to the mail side.
Mr. Aldridge. We're gonna start with Mr. Brown, Your Honor. Mr. Aldridge, you stepped out to use the restroom.
Okay. Mr. Brown.
Good morning,
Good morning, sir. You're charged with one count of theft by receiving stolen property. This is a misdemeanor offense. Your bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, Your Honor.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, Your Honor, I have a retained attorney.
Okay. Do you have any questions of me?
Yes, Your Honor. If you would consider, I just bonded out of Cobb County on a $45,000 bond. And, having paid that bond, I had wanted to ask if you would consider granting me a signature bond. I will be prepared to show up to court and, handle all of the charges at hand and, show up to all of my court dates with my retained lawyer, but I missed the birth of my son on December 5th, and I was also incarcerated for Christmas, so I just was gonna take the risk and ask you if you would consider that.
No, there is no problem in asking, but I'm not going to grant you a signature bond. Okay. All right, sir, you're free to go back.
Bo.
Mr. Bo, sir, you're charged with one count of forgery in the third degree. This is a felony offense. I've set a bond at $10,000. Do you believe you can post that bond?
What?
$10,000. Do you believe you can post that bond?
No, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post a bond, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Are you currently working, Mr. Bo?
Yes, sir.
About how much do you make per hour?
$10.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Mr. Aldridge.
Mr. Aldridge, sir, you're charged with one count of criminal damage to property in the second degree. This is a felony offense. Bond is going to be set at $5,000, and one count of simple battery, family violence. Bond is going to be set at $3,000. So that's a total bond of $8,000. Do you believe you can post that bond?
Yeah, yes, sir.
There's going to be a stay away provision on the bond to stay away from a Shade Fowler. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah,
Are you currently working, sir?
yeah, work for Walmart.
About how much do you make per hour?
I make $22 an hour.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, that's my daughter, who you said that the victim, but my wife is pregnant. So
Okay,
she's 8 months pregnant. So I'm trying to get back home to my wife.
okay,
I'll be able to make the bond today.
okay.
Okay, sir.
All right, you're free to go back.
Thank you so much.
You're welcome.
All right. Mr. Colborn.
Mr.
Colborn.
Mr. Coburn, sir, you charged with one count of violation of Georgia Controlled Substance Act. I've set a bond at $3,000 for that offense, and one count of obstructing an officer. I've dismissed that count. So you're going to have a total bond set at $3,000. Do you believe you can post that bond? Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Are you currently working?
No, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, you're free to go back.
Thank you.
You're welcome.
Jenkins.
Mr. Jenkins, sir, you're charged with one count of failure to have your headlights on. Bond is going to be set at $500 for that offense. One count of use or possession of drug-related objects. Bond is going to be set at $1,500. And one count of simple possession of a controlled substance. Bond is going to be set at $3,000. So that's a total bond of $5,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
No, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. Sir, I'm a veteran, and I need to know, do y'all have veterans court or veterans attorneys through Clayton County?
Judge Robert Mack in Superior Court is trying to get a veterans court started. If you want me, I will refer you to your case to his assistant for them to determine whether you qualify.
Okay, and then the other question is, I have two major surgeries coming up. One in 4 days, my right kidney is being removed. And then 2 months later, I'm having a total right hip replacement. So I will not be able to go in and make any court dates.
So currently, if you bond out today, you're probably not looking to another court date for another probably 5 to 6, maybe 7 weeks. I don't know.
Okay, so if it comes up between one of my surgeries, I don't want to violate my bond and stuff by bonding out and then not be able to go to court.
Okay, so I've appointed a lawyer to represent you. I know you don't know who that person is right now, but it's going to be someone from the public defender's office here in Clayton County. And you need to stay in contact with your lawyers as to whatever is happening with your life.
Roger that.
Okay.
Roger
All right,
that.
sir. You're free to go back.
Mr. Johnson. Yes.
Mr. Johnson, sir, you're charged with one count of driving in a vehicle without a valid license. Bond's going to be set at $1,000. And you're charged with one count of possession of more than an ounce of marijuana, but it actually, the amount that they've listed in the warrant is less than an ounce, and one count of possession of a controlled substance. I did not see sufficient evidence for those two charges to go forward. So those two felony charges are going to be dismissed. And you're charged with one count of use possession of a drug-related object, which is a misdemeanor. Bond is going to be set at $1,500. So you're going to have a total bond on these misdemeanors set at $2,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
$15 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you.
Okay, you're free to go back.
Mr. Lewis.
How you doing, y'all?
Mr. Lewis, good morning, sir. You're charged with one count of homicide by vehicle in the second degree. This is being charged as a misdemeanor. I've set a bond at $10,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
Yes.
About how much do you make per hour?
15 and all.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Mr. Marcus.
Mr. Morris, sir, I'm sorry, Mr. Marcus, sir, you're charged with one count of criminal trespass, damage to property is being written as a misdemeanor. Bond's going to be set at $2,500. Do you believe you can make that bond?
No, sir.
There's going to be a stay away provision on this bond, a stay away from a Jakarta Lions. Do you understand that? I'm sorry, sir.
Can't make the bond, sir. I won't be getting out no time soon.
Okay, we're on to the next question. There's a stay away provision, a stay away from a Jakarta Lions. Do you understand that?
No, sir.
What do you not understand?
That's why I didn't rent it.
I'm sorry?
Yes or no? Yes or no? No, sir. I don't understand that, sir.
Why do you not understand a provision to stay away from Jakarta Lions? What is that about that that's confusing?
Because I don't have nowhere else to go. That's the only place I have to go. That's the only thing I'm saying, sir.
Okay, so Mr. Marcus, during the pendency of this case, unless this stay away provision is removed, it's going to remain in place. So if you were to call Miss Lyons from the jail, that could constitute a felony of aggravated stalking. And sir, I'm not asking you to agree with me. I'm just trying to inform you. You can act accordingly. You can do, you're a human being in the United States of America. You can do whatever you want to do, but there are consequences to actions. My job as a judge is to make sure that you understand that if you decide to disregard what I've said, when the consequences come, you can't say, I didn't know. So do you understand that if you go around Miss Lyons, if you contact Miss Lyons, while this provision is in place, you will receive a felony offense. Do you understand that?
No, sir.
What do you not understand about that?
That's what I pay my rent at.
Sir, that's not a response. What it sounds like you're saying is you don't like that. You don't like it because I pay my rent there. So I don't like the fact that I can't go back there. That's not what I asked you. I said, do you understand if you go back there, you're going to get a felony charge and you're going to be in custody until your trial? It's up to you. You can stay in jail as long as you want to. It makes me know, never mind. My job is to make sure that you understand.
I'm trying to.
And so, sir, this is being recorded, just so you know, so that if you decide to do what you want to do and you say the judge never told me this and the judge never told me that, this recording comes out. So it's your life. You get to live it the way you want to live it. And if it wants to be in an orange jumpsuit in the Clayton County Jail, God bless you. Have at it. My job is to try to make sure that you understand. So I believe that I've said it now 3 or 4 times. I'm going to move to the next point. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. If you're able to make bond, that date will get waived and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Yes or no? Okay. All right. Is there anything else, Mr. Marcus? All right, sir. You're free to go back.
Your Honor, can you repeat, Mr. Already's total bond again?
Yes, $8,000.
Okay, the whole total, right? Yeah, I appreciate it. Thank you.
Mr. Murphy, Murphy.
Okay.
Mr. Murphy, sir, you're charged with one count of driving a vehicle on an expired or invalid tag. Bond is going to be set at $500. One count of having a child that is not restrained in a child seat. Bond is going to be set at $500. One count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. And one count of possession or use of drug-related objects. Bond is going to be set at $1,500. So you're going to have a total bond set at $4,000 for these 4 misdemeanors. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, I'm okay.
Okay. Do you have any questions of me?
I get that child restraint, ain't got no child.
Okay. So the allegation is
Is that on?
No, you ready?
Oh, that's on.
you know what? It's a seatbelt violation. On the bond order, it says child restraint violation, but it's a seatbelt violation. Okay, any other questions? Okay, you're free to go back.
Mr. Ross, Justin Giovanni Ross.
Okay, Mr. Ross, sir, you've had a busy year. Possession of disposed or vehicle. Let's see, how are they writing this? Felony attempting to conceal the identity of a vehicle. Bond is going to be denied on that charge. Possession of a firearm during the commission of a crime. Bond is going to be denied on that charge. Theft by receiving stolen property. Bond is going to be denied on that charge. Concealing the identity of a vehicle through the tag. Bond is going to be set at $500. Speeding. Bond is going to be set at $500. And improper lane change. Bond is going to be set at $500. So you're going to have 3 counts with no bond and a $1,500 bond on the 3 remaining counts. You're going to have a preliminary hearing date set for February 7th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for February 11th at 8:30 in the morning. Do you currently have a lawyer on your other offenses?
No, sir. I'm not questioning.
Okay, so do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify, Mr. Ross. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir.
Yes, sir.
Like with those charges, that truck didn't belong to me. It was my boss's truck. And how could I go about having him come up here to admit the ownership of it, because that's what we were supposed to do.
Okay, so this is where the lawyer comes in, and the lawyer becomes a person, or the investigator becomes a person that works through this. If you're able to show that the owner of this vehicle is not you, then that could go a long way in having those 3 charges dismissed. However, given the fact that the identity and all of this stuff was kind of hidden, it may be difficult to be able to show that.
The truck was only in my possession because it was during work. I was at work. I was just driving at work. And I was just trying to figure out if there was anything I could get a bond for that, because I do need to get out to get my job.
Well, it appears like this is the 3rd time that you've been arrested this year. So that becomes an issue as to why the bond is being denied. It's not because this is the crime of the century, but it appears as though you're just going to keep coming back to jail. So if you're going to keep coming back to jail, maybe you just need to stay in jail.
I understand, but this time it wasn't my fault, is what I was saying. It's not under my conditions. That truck doesn't belong to me. I just went to work, and I do have my boss to admit that.
And believe me, if that information is before me, these charges will be dismissed and you'll be out on the street.
I'm saying, is there any way I can get him to get in contact with you somehow? Was it too late?
Well, yeah, it's kind of no, it's never too late. Did you tell the officer that this wasn't your vehicle and it was your boss's vehicle, and gave the officer the contact information to contact?
He didn't want the contact information. He just told me tell him to come to court.
Okay. So, Mr. Ross, you have to, in my opinion, understand that, like I said, with 3 arrests this year, you're not looking to be a pretty, credible person. Stuff happens, right? But your word is not going to be worth as much if you had not been in a situation where you have been arrested 3 times this year. Does that make sense to you?
I understand.
It's like, the best way I've heard it explained to me is like, if you cheat on your girlfriend and she takes you back, she still is not going to forget the fact that you cheated on her. And you come home late, and you could have been handing out winter coats to homeless people. She's gonna, in the back of her mind, think, was he with that woman again? So it just brings into question things that ordinarily would not be brought into question. So that's the lens that I'm viewing this through.
I understand. Is there any way possible that I can have this evidence brought to you? Because, Your Honor, I can't sit here until the 11th. I got priorities and children.
I understand. So the lawyers, when this will be in the public defender's office, we're doing preliminary hearing calendars every week. And I'm not doing preliminary hearing calendars next week. I'm doing preliminary hearing calendars the week after that. But every week there are preliminary hearing calendars that are going on. And if there's something that's brought up, I sign stuff all the time for cases that are set 3-4 weeks out, where they've reached an agreement on something. So the short answer is that you don't have to sit here, but there's going to have to be some proof to show that what's in here is just patently incorrect, and you're just being basically the person that's held accountable for somebody else's misdeeds.
And I will go about doing this by having them go to the public defender's office.
It's the public defender's office, and again, if your boss is willing to say, "Hey, no, he was driving the car. He can sign an affidavit to that effect.
Okay, thank you, officer. I mean, thank you, Judge.
Okay, all right, sir, you're free to go back. Mr. Shu, is it? Shu?
Yes, sir.
Sir, you're charged with one count of simple battery. Bond's going to be set at $3,000, and one count of cruelty to children in third degree. Bond's going to be set at $3,000. These are both misdemeanor offenses, so that's a total bond of $6,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond, stay away from a Rich Marie Otero. Do you understand that?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, but I have a question, sir. Oh, what I was charged, they was saying I was only charged with third degree of cruelty to children. I didn't know I had a battery charge, sir.
The simple battery. So, I don't know why they would say that. The way that the child cruelty in third degree is, the way the statute is written is that you knowingly allow a child to see an act of violence. So if they're charging you with child cruelty in third degree, that you allow the child to see an act of violence, how can they not charge you with committing the act of violence?
Right, okay, sir, but, then, yes, sir.
Okay, so would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir, I am.
About how much do you make per hour?
15 an hour, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions, any other questions for me?
No, sir, I do not.
Okay, Mr. Wilkins, you're free to go back, Mr. Shula. Mr. Wilkins, you're charged with one count of theft by receiving stolen property being a motor vehicle. Bond is going to be set at $10,000 for that offense. And one count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. So that's total bond, $11,500. Do you believe you can post that bond?
One quick question, what's the percentage on 60%?
Yes, sir.
On the $10,000, what would be 60%?
You're looking at anywhere from $1,000 to $1,500.
Okay.
Roughly.
The debt, I'm not sure if I better afford that or not, listening to the chart. But, well, I know I can bond out on possession, but with the $10,000 bond, I make a couple phone calls and see if somebody be willing to help me make that bond. But as of right now, no, sir, I will not do that.
Okay. You're gonna have a preliminary hearing date set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Are you currently working?
Yes, I work 2 jobs.
About how much do you make per hour?
The first job is 16 and the second one is 14.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
Other than being on our part, that would be the only question I have, but I understand if you say no, if you give me a no, and I understand that because I put myself in this position and I have to get myself out. But I was gonna ask you that question. I do have to get back to my job as soon as possible. But I understand if you say no, because like I said, I did put myself in this position and I have to get myself out.
Okay. And I was going to say no.
Okay.
Okay, sir. You're free to go back.
Okay, thank you. Have a good day.
You're welcome. Is it Mr. Gabriel?
Yes, Mr. Gabriel, he's coming up.
Gabriel. Mr. Gabriel, sir, you have the same rights and privileges as everyone else that I mentioned before, but you're in a slightly different position. You're here on what's called a fugitive from justice warrant. And what that simply means is that there's a warrant for your arrest out of another state. And in your case, it looks like it's Harris County, Texas, that they have a felony warrant for, looks like the charge is criminal mischief. And they've indicated that they will extradite. So when you're arrested on a warrant like this, you have the right to contest this warrant or extradition process, for lack of a better term. And what that means is that if you believe that you're not the person named in the warrant, or you believe that the warrant alleges a charge that is non-existent or is no way that that could happen, you can request a hearing. And if you request a hearing for the judge here in Clayton County to look into that, sometime between now and the next 90 days, you will have a hearing. And at that hearing, it's not going to be a situation where there's a termination of your guilt or innocence. It's just going to be whether you're the person named in the warrant and whether this warrant actually exists. If after having the hearing, the judge determines that those conditions exist, the judge will sign off on the extradition warrant, and then the state of Texas will have a 30-day period to come and get you, up to a 60-day period if they request a 30-day extension. If you believe that you are the person named in the warrant, and if you believe that these charges are possibly credible charges, not that whether you're guilty of it or innocent of it, but that these charges exist, you can waive that 90-day period to have the hearing and say, I want the clock to start ticking today. If you were to waive that hearing, the clock would start running today. The state of Texas would have 30 days to come and get you. They can also request an additional 30 days as if in the other scenario. And whether that's granted or not is something that is within the total purview of the sheriff's department. Do you have a lawyer representing you in Texas on this charge?
Yes.
Have you spoken to that lawyer?
Not since last month. I haven't, maybe it's the holidays, but my last, I had COVID last month and I was in a hospital. And on account of that, I missed my hearing, or my appearance in court. That was December 9th.
Okay.
But I was sick with COVID and I have it documented.
Let me ask you this. This just happened last week with a person who had a warrant for his arrest out of California. He had lawyers representing him out in California on the charge, and there was a preset bond out there. His family was able to make the bond, and they sent the information over to the sheriff's department, and that person was released. Do you have any idea whether there is a bond set in Texas on this?
Well, initially, I paid, I think it was I believe a $15,000 bond. I believe it was 15,000.
Okay.
And and my family helped me post the bond. Is that what you mean?
So, let's see. I am going to, today is Wednesday. I'm going to be doing first appearance tomorrow. And I will be around on the 31st, even though I don't have a calendar. Do you believe you can get in contact with your lawyer in Texas? Uh-oh. Okay, looks like We're gonna have to wait for them to come back on. I'm gonna stop my video and audio.